Could I just have a couple of weeks to provide some opposition?
Opposition to what?
The government's motion.
No.
What are we doing?
That was part of the frustration that I had with the papers.
Complex legal issue that we're talking about. It's like...
So you've been in possession of the phones since January of 2024 and are only now requesting leave to download the information and search the phones.
The hearing on whether or not the Commonwealth is going to be able to download and search Karen Read's cell phones. Now we have a hearing, arguments in front of the judge, who is not happy. The judge is not happy. He's not happy with how the lawyers have handled this. And Turtle Boy's lawyer is at this hearing as well, because this is the Commonwealth versus Turtle Boy case. And he makes some arguments at the end of the hearing that really make you go, So the lawyers here on the left in the tan suit is Bradle, Turtle Boy's lawyer, and on the right, or in the blue suit, is Buzang.
The handsome lawyer you know is back, and he's watching a hearing regarding Karen Read's cell phone and whether or not the Commonwealth can analyze it, even though she was already found not guilty. Let's watch.
Who is Karen Read's lawyer? You're going to see a bald attorney, that is Cosgrove, who is the, I guess, special prosecutor on some of Turtle Boy's cases. But the judge makes some interesting points about how the lawyers are like two ships passing in the night as they're arguing here, and he's not happy about it.
Let's deal with Mr. Buzang's matter, but it really is a request for setting a set of conditions for searching through Ms. Read's under a protocol that would assure against the sharing of privileged information. The Commonwealth's request and Ms. Read's response spoke completely past each other.
The Commonwealth seized Karen Read's phone pursuant to a search warrant. They never actually downloaded any of the information because they never had a password and because they're simply lazy. They have had the phone for over a year now, and because it may relate to Turtle Boy's case of witness intimidation, they now want to go through it.
And didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
In typical Massachusetts fashion, the judge really doesn't know the facts of this case. He believes that Karen Read's cell phone had already been downloaded. It hadn't, because they don't have the password. But that's what the judge thinks based upon the parties' written submissions.
It has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. I think I authorized the download, and I thought that there was a representation in the papers that it had been within days of the authorization. Let me just see if I can find it in the papers.
I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side.
Wait a minute. I recognize this guy who's claiming he's not tech savvy. He was the one who claimed Little Johnny, the rhino we hired to reenact the point when Higgy Bear chased old Turtle Boy while he was driving by his house, was AI.
I got my camera. So he's quoting this guy. That's not my video account. That's Loophole Lawyers.
This is a portion of the video that the prosecution cited, claiming that it was AI and not real Little Johnny.
Almost there, just a little more.
After Cosgrove's defamatory statement, we submitted video from behind-the-scenes footage from when we filmed.
Such a good boy, isn't he? He's a natural on set.
Little Johnny certainly was a natural, and he was a pleasure to work with. Little Johnny was born into captivity, has starred in over 50 different movies, and like myself, is a member of the Screen Actors Guild. After Cosgrove made those defamatory statements, Little Johnny's Jewish manager Shuli kept calling us, demanding that we rectify the situation.
Perfect. This rhino is gold, I tell you. Gold.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Buzang presented in his opposition, which is the Commonwealth, having been in possession of the phone for an extended period of time, has a finite amount of time in which it can seek authorization to search or to do the search. So in your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Read. After review, Krupp authorized the warrant. The search was executed on January 24, 2025, indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. I thought that there was something in here that said that there was a download, but maybe I mistook that.
I don't know, but my understanding is that the phones were seized.
Phones were seized
Full stop.
and they haven't been searched. So you've been in possession of the phones since January of 2024 and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is a practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a search protocol.
Well, what do you say to Ms. Reed's argument? There's a certain amount of time you have to download if you have the phones. Now more than a year has passed, and it's only now being requested.
There's no question that more than a year has passed and it's only now being requested. If Ms. Reed is right, I think that would be dispositive. But I don't think there's any basis in the case law for concluding that Ms. Reed is right.
Despite having the phone for over a year and not being able to download it, they never made any motion to the court to get Karen's password. Now they're claiming they need her password in order to effectuate the download. And Cosgrove's making a good argument. He's saying the case law doesn't give us a time limit for which we have to download information from a phone after we get it using a valid warrant.
And as we read the cases and the whole 123 days and all that stuff, to me, that's not like a bright line rule that the court has to follow, or else they would say you only have 123 days. That does not exist. We're going to hear them argue this. The point is, what's fair? What's justice? That's what we should be fighting for here. And it just seems like such a crock the way they go through this, and they're parsing it out like it's some complex legal issue that we're talking about. It's like... No bill, hung jury, acquittal, jurors come out and say factually. What are we doing?
That's a great argument by the handsome lawyer you know, and for all the broads out there that claim this guy is just a pretty face, clearly he's got the brains as well.
Her phones back. It's crazy. When people watch stuff like this, you understand why they get frustrated with the justice system, because this is BS from the prosecutor and the judge needs to do the right thing. I'll be honest, when I first went to the website, I went right to the FSU gear and found this little zip pouch, which is absolutely perfect for me to put my tees and ball markers in for golf and leave it in my golf bag. And it is so cool with so many little details on it. But I kept looking, of course, for other people in my life.
Yet, despite being rich, good looking, and smart, he always has to pitch some form of a product in all of his videos.
Case law suggests that a warrantless search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth.
Karen Reed's attorney cited a case called Diaz. In that case, the state obtained property from a defendant without a warrant. In this case, there was a warrant issued, so it isn't really relevant to the actual issue before the judge.
That rule is designed to protect the defendant's possessory interest in the phone. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant.
Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And
Yes.
here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang, is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
There's nothing worse after spending hours on a brief citing multiple cases and then the judge asking you on the spot to cite a different case with different facts.
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly, Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially evidence in a case, right, that there was probable cause or a basis to issue the warrant. So So the question is whether you have a case that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones, or any other piece of evidence. You know, warrant authorizes the seizure of hiking boots, and there's a 1.5 year delay on doing DNA testing to see if the boots trudge through mud or blood or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the Fourth Amendment and Article 14 of the Search and Seizure Law requires law
The judge is not asking Karen's lawyer for argument. He wants an actual case.
enforcement to act diligently to obtain a search warrant without unreasonable delay.
And here they did by seeking a search warrant for the seizure of the phones. The question is whether there's an independent, any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself.
You can hear the differences in the arguments. In Diaz, the cops apparently seized a phone without having a warrant. There, you would want to have something very quickly done in order to return that phone if it's not needed for the actual hearing. Here, because the judge reviewed a request for a search warrant, Karen was afforded additional protections. Therefore, the time limits are not necessarily equal when you compare the two.
In a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued.
When you hear that attorney say no bill, he's referring to the fact that a grand jury actually reviewed the facts and circumstances around Karen Reed's phone and whether or not she intimidated a witness, and issued what's called a no bill of indictment, meaning they didn't find that there was probable cause that she actually committed the crime.
Here they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case.
And the judge, by the way, my dad and I were talking about all these tough questions he could ask the prosecutors as to why the delay, why are we doing it like this, why now, what do you plan on getting it, do you really think that there was enough probable cause in the original search warrant? And the judge, of course, is about to ask 0 of the difficult questions.
100% agree.
Now they want to come back and look at her 2 phones, and they have all that evidence from Mr. Kearney. They have, I think,
all right,
5
no,
or 6.
I understand those arguments, but I'm still trying to find a case, if you have one, that comes up in the context of a warrant authorizing the initial seizure of the device, and then there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
I don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the Fourth Amendment, this would have, I don't think would have came up if we just let it stay and didn't ask for the 2 phones. It was only after I asked for the 2 phones that now this is somehow an ongoing investigation. When they've had the investigation was done, and there was nothing to it.
Okay, I'll take it under advisement. If the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
The second issue the judge needs to decide is if he allows the download and search of the phone, who is actually going to oversee it? The state has their own proposed people.
What did you write after you talked about going through the, quote, retarded client's phone?
No nudes so far.
No nudes so far. And you said that to your bosses.
Yes, sir.
You were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
And obviously the defense wants somebody there as well to make sure that they're only searching portions of the phone for which they're allowed to.
No nudes so far.
And that no privileged information or irrelevant pictures or videos are there and searched for.
I do, Judge. I don't think the Commonwealth, the defense has some say in, who would be a part of the tank team. So I don't take the representation from the government that they should just set it up.
I don't have any opposition from you or any substantive response to you with regard to the protocol that's proposed by the Commonwealth. That was part of the frustration that I had with the papers.
Looks like Karen Reed's attorneys just assumed they were going to win and not have the state actually download Karen's phone and they didn't propose any type of protocol just in case the state actually gets to download and review the documents and information on the phone.
They came to me. Protocol laid out here in the Commonwealth's papers. I take it you can make a backup of the phones and do the search off the backup, and you can promptly return the phones to Ms. Reed.
But before we get to that, Judge, could I just have a couple of weeks to provide some opposition to that?
Opposition to what?
The government's motion.
No. You can talk to Mr. Cosgrove, talk and come to an agreement as to a protocol. And if there are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason, not a long brief. If I'm going to allow this, there's going to be a taint team protocol put in place. I assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I'll give you 10 days to do that. I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version. I'm likely to be more like a baseball referee, is take the version that I think without fiddling too much with the language. So both sides really need to be reasonable.
Karen Reed's team kind of threw a Hail Mary. They're like, all or nothing, Judge. No way you should allow them to search the phones. We don't even want to talk about the protocol that they've produced. We don't want to give our kind of protocol because we don't think there should be anywhere near allowing them searching these phones. And the judge is like, I need your ideas on the protocol. What does that tell you? Well, if the judge had already made up his mind that he was not going to allow them to search these phones and he was going to give these phones back to Karen Reed, he wouldn't care about the protocol. He wouldn't care about these arguments. So I don't know that he is absolutely going to allow them to search the phones, but he has absolutely, as he sits here today, not made the decision to give them back to Karen Reed.
I have to agree with the handsome lawyer. You know, most likely the judge is going to allow the download of Karen Reed's phone, but he needs to hear from both sides as to how they're going to do it and who's going to oversee it. Despite the fact that a grand jury refused to even indict Karen Reed on this issue, she's being dragged in because of her relationship to Turtle Boy, who is facing current criminal charges with regard to witness intimidation. It appears the state of Massachusetts is just being vindictive and is now only asking to download Karen Reed's phone after they lost the case and after she requested to get it back. There must not be any other crimes in Massachusetts if the state is going to devote so much time and energy just to look at Karen Reed's phone after a grand jury decided not to indict her. We will link to the actual hearing in the description, but I'm going to warn you, almost every other word is a connector. Like you know, you would think people that have so much experience speaking in public would learn how to reduce or eliminate those like you knows. Like you know?
Or